CMC is being held by way of teleconference. Any orders or directions made after or during the course of the CMC will be issued by the Registry on Dubai on Justice Sir Richard Field's instructions. We are here for a CMC in the matter of TCD-003-2019 before Justice Sir Richard Field. The claimant is represented by El Tamimi and Company. Lead counsel is Patrick Dillon Malone. The defendant is represented by Ibrahim Al-Banna Advocates and Legal Consultants. Lead counsel is Santano Ghosh.
Yes, well, thank you very much for that, Mesa. Well, Mr. Dillon Malone,
yes,
you represent the claimant, and it seems to me there are two principal matters that we have to deal with, as well as I expect a number of subsidiary matters. The first is an application for 50% of the costs that have been awarded so far that are subject to assessment under the practice number 5 of 2014. And the second concerns how we fit in the separate claim of the defendants in as a counterclaim. Do you agree that those are the principal issues?
Yes, certainly on the second, yes, and I don't think the counterclaim position ought to be controversial. It's something which makes eminent sense. On the first application, it's not precisely that application for the 50% is now really my alternate application, because the costs order that we issued that 50% application in respect of is the costs order from July of last year, which was a simple order for costs to be assessed by a registrar if not agreed.
Yes.
We wanted to get, just to explain very briefly, we wanted to get to a position of enforcement quite quickly because we wanted to have an execution step on shore. And my client instructed us, therefore, to issue the 50%. That application then never proceeded because it was just a hesitation, and for various reasons, that application didn't proceed. And then now that we have this CMC, it's my primary request application for you that you exercise that assessment jurisdiction of the registrar pursuant to the order from July and simply assess. And that's why the sum in the draft order is based on the full amount as set out in our costs statement of costs, which was filed in September, plus certain additional items which are explained. So I'm not sure what the position of my friend is in relation to that, but it's my respectful submission that is an appropriate way to proceed, avoids and is the most efficient way to proceed and the most fair way to proceed, to simply assess.
Well, now, it strikes me that it's somewhat novel to have on a CMC, particularly one that's conducted by a justice of the court, to have an assessment of costs. Ordinarily, that's the role of the registrar, and that was the order that was made. Well, at least one of the orders that was made, that you had an award of costs which were to be assessed. I think those were the costs in respect of the default judgment and the application to set it aside.
Yes. Yeah. It may be a little unusual, but I think that the court has that power of assessment under the rules, and that it is usually one has the debate as to whether a registrar can exercise the power of the court, but the judge, you respectfully have the full power to assess. You have all the material before you, and I'm asking that you please do consider the matter. As I say, I have the alternative for the 50%, but it seems a bit wasteful in the circumstances when we have you before us.
All right. Well, now I'm having a bit of difficulty in hearing you. I have managed to hear you, but can you just give me a minute? I'm going to see if I can amplify your voice. Hang on. Can counsel hear me clearly?
Yes.
Oh, loud and clear.
Yeah, loud and clear. Yes.
Oh, good. Well, I'm hearing you a bit better now. Well, I think what we'll do, Mr. Dillon Malone, is to I'll let you get your application underway, but I may well have to come back to this question as to whether it's inappropriate in this CMC for myself to undertake an assessment of the costs.
Yes.
In the commercial court in London, and the DIFC courts are to some considerable extent modelled on the London court. It's unheard of that a commercial court judge undertakes a detailed assessment. It's all done by one of the masters of the court, now called a cost judge. And I've never come across this before at all in the DIFC court, that on a CMC conducted by a justice, costs stand to be assessed. But however, take me to the fundamental documents.
Yes.
Take me to your application to have the costs assessed rather than 50% on account, and let's see how we go.
Well, procedurally, you may even have a greater hesitation in light of what you said. I don't have an actual application. I don't have a Part 23 application before you on the assessment. I have the application for the 50%. I have the order that was made in July, and then the statement of costs that was filed on the 21st of September. So
yes, I've seen all those, and there was a handwritten amendment to.
Yes, the reason for that was that I don't know how the figure that came out when we filed the commence. To explain, the registry advised us that in order to have the 50% application considered, we ought to serve a notice of commencement of assessment and pay the appropriate fee, which was about $3,500. And as I say, there were other considerations which delayed that application of taking its course. And it was only just a few days ago last week that we made that payment. But when the automatic form issued from the registry, it had this, I don't know where that lower figure came from. So in consultation with the registry and on notice to my friends, we put in the figure that corresponds to the figure that I have included in the draft notice by hand, and the registry kindly then reissued that. So
Yes.
nothing turns on that particular document. I think it's a procedural or it's an administrative record. I think the two documents that you need to look at are the order from July,
Yes.
Which is the at page 18.
Yes.
And you'll see on page 19, paragraph 2, it's a simple order that the defendant shall pay the claimant's costs of application by the default judgment and the first application. And the first application is defined as the set-aside application. And the circumstances for that, Justice, are probably, I think you are probably aware of those circumstances. When the set-aside application was made, my clients took the position, in the interests of saving costs and time for everybody, that they would concede the set-aside, they would consent to the default judgment being set aside, and sought the costs, and those costs were then ordered not on a consent basis, included in the set-aside order of 8th of July. So that is the order that I'm seeking you to give effect to. I suppose on the unusualness point, judges do immediately assess costs, and at a hearing, the conclusion of a hearing, or following the conclusion of a hearing, if it's an immediate judgment, if it's an immediate cost assessment process. And it seems to me that this one is very much akin to an immediate assessment. And the statement of costs is at page 33.
Yes.
Recall that this was in respect of two applications. So it was the original default judgment application, and we took care in the statement of costs that was filed in connection with that, which is also included in the papers, to make sure that no costs of the initiation of the proceedings were included in that. It was carefully delimited to the cost of obtaining the default judgment. Similarly, then, when we added in the hours and time for the application, they total a grand total of 153,627.50, which you'll see was not only related to the documents as the main element of work, but also quite a bit of time spent with advising our client by way of attendance, because it's particularly in relation to the second application, the set-aside application. Can you hear me?
Yes, someone seems to be interrupting our conversation.
I don't know who that is.
But just carry on, Mr. Dylan Malone.
I was just explaining that you'll see in the attendance on others.
The grand total is $74,059.25.
That's the 50%. No, on page 34, Justice Field, on page 34.
Oh, I'm so sorry. On page 34, yes, go on.
Yeah. This is the statement of costs. The 50% is the 70 figure that you just mentioned. The full sum is 153,627.
That's right. Yes, I'm with you.
Thank you very much. And the point I was explaining briefly was that you'll see almost evenly in terms of the costs. There is an element of attendance on others, which includes attendance on our own clients, in working out with them the consequences of the strategy that they wanted to adopt, which was to not contest the set-aside application, and that is why those elements are there. But in my respectful submission, the costs are proportional, reasonable. They were reasonably incurred, and if the court has any questions in relation to them, I can assist. I should explain that Rashid Khan is my associate colleague who has mostly worked with me on this. The other fee earners are the partner, research supervising partner with a small amount of supervision, and some contribution from Mr. Lloyd, who is a part of our construction law team, who has a strong relationship with our client.
Well, I'm a complete novice when it comes to a detailed assessment of costs. I do know from conversations that I've had with the registrar, the deputy registrar, that there are certain rules of thumb which registrars apply when determining whether the costs have been reasonably incurred. These rules of thumb are unknown to me, and I'm afraid I'm not prepared to allow this application for an assessment, full assessment, which has not been. First of all, the assessment is ordered to be by the registrar, and it seems to me that you need some form of originating application in any event, which you don't have. You do have a proper application for 50% under the practice direction.
Yes.
So I regard myself as having proper jurisdiction to determine the 50% application, but I'm not going to entertain an application that I assess the costs in the course of this CMC. Of course, if it is appropriate to order a summary assessment, then the court undertakes the assessment. But a judgment has to be made whether it is appropriate to have a summary assessment or not. And the implicit judgment that's been made, having regard to the order of July, is that this is not appropriate for a summary assessment, but should be the subject of a detailed assessment. And so I'm unconvinced by the contention that because judges do summarily assess costs, then it's appropriate for a judge to undertake a detailed assessment. So I'm afraid, Mr. Malone, I'm not going to undertake the detailed assessment that you would like me to undertake, but I am quite ready to deal with your application for 50% of the costs.
Thank you, Judge.
Now, yes, I'm sorry, do go on. I didn't catch that.
No, I was just saying thank you, Judge, and I fully have noted the position, and in the circumstances, the document upon which we rely, or the documents upon which we rely, are all in the bundle. I do not believe that it's necessary for me to subject to your lordship, necessary for me to open everything. There is a sequence behind them.
I agree.
And I make the application, therefore, for 74,059.25, as set out on page 30 of the bundle.
Yes. Well, thank you. I'll hear now from Mr. Ghosh. Mr. Ghosh, what are your submissions in respect of this application for $74,000 odd on the basis that this is 50% of the costs which are set out in the statement of costs?
I'm sorry, Justice Field. It's a dirham amount. Excuse me for interrupting.
I'm so sorry, I didn't get that. We've not got good reception here. And do forgive me, could you repeat that, Mr. Malone?
Yes, I apologize for interrupting. It's to point out that the amount is a dirham amount, not a dollar amount.
A dirham amount, and not a dollar amount.
Yes.
Very well, thank you. I should have spotted that. Thank you very much. Well, Mr. Ghosh, what are your submissions?
Yeah, thank you. I hope you can hear me.
I can hear you well.
Yeah, thank you. I have just two submissions. I had requested that because we have a counterclaim, so we can keep it till the end. Because the judgment, it says that either we keep it in the end for the final judgment or we assess it now. Now, in July, it was not assessed, so the costs went up considerably after that. So obviously, there is a doubt about the amount which my friend Patrick is saying. So if any assessment is done, then I leave it to your lordship. I'll not get into it, but my only point is that it may be kept till the final judgment is passed in this matter, keeping in mind that we also have a counterclaim. So if anything is in our favor also, it can be set off and accordingly dealt with.
Yes, well, thank you very much. I understand that submission perfectly well. However, I'm not going to accept the submission. The whole point that underlies the entitlement to a sum on account is that it represents a just cash flow position in respect of the successful party.
Yes.
Costs are always taxed down to some extent, but there's no good reason to keep a party who's been awarded costs in respect of an intermediate matter that's arisen in the course of proceedings entirely out of any costs until the detailed assessment has been undertaken. And it's a completely standard procedure that an amount on costs can be ordered well in advance of the final determination of the claims in the proceedings. So I'm going to make the order sought that 74,000 odd dollars that are dirhams, which are sold 74,059.25 dirhams, must be paid. Now, Mr. Ghosh, how long do your clients want in order to make this payment?
Just give me, 14 days is good enough.
Well, I'll give you 10.
Okay. I leave it to your lordship. Submission is 14 days.
So the sum specified, 74,059.25 dirhams, must be paid within 10 days of today.
Very well, your lordship.
Right, coming back to you, Mr. Dylan Malone, what are the other matters on the agenda for this CMC?
Well, I think that the counterclaim edition, if I could bring you to the order, the draft order of page 59.
Yes.
Commencing at page 59.
Yes.
And there's a first section called pleadings with reference to part 56.
Looking at it, yes.
And this is my friend's application to which we are effectively consenting. We do wish to include the important paragraphs 2 and 3 that the other proceedings will be struck out with no order, and for the avoidance of doubt that the order made on the 27th of October in the other case is without effect and has no application to the present case. Now, I do need to explain that to the court very briefly.
Yes, please.
The order made on the 27th of October was a simple order on the application of my friend, of which we knew nothing. We knew nothing about these other proceedings. requesting leave to add a company called AAB Holdings Limited as the second defendant in the other proceedings. And the court granted that. The court granted that permission, the judicial officer. As you know, that's an application which can be made without notice, and it was made without notice and granted without notice.
Yes.
In the context that was never acted upon by MESC, by the defendant in these proceedings, and
yes,
what happened was we became aware of it through pleadings filed in parallel onshore proceedings, which are now before, which at the time were before the Court of Appeal in Dubai, and are now before the Court of Cassation in Dubai. And having become aware of the existence of the order and being surprised by it, we wrote to the other side a couple of months back, and we said, look, you know, we will take an application, if necessary, to strike out on behalf of the AAB Holdings. We'll make an application to discharge that order, to set it aside effectively. And to which we received a response from Mr. Santanu, Mr. Ghosh, to explain that his clients did not intend to actually act upon that and were not adding AAB Holdings in those proceedings. So all very good to that effect, and then matters moved on, and we are at the point now where, by agreement, that counterclaim is going to become the counterclaim in these proceedings, which makes eminent sense, and no order as to costs, because we didn't incur any costs in this proceeding. But the point is that despite that correspondence and assurances, unfortunately and regrettably, AAB Holdings, the issue of AAB Holdings, and in reliance upon the order dated 27th of October, has continued to be, I don't want to be emotive, but brandished, if I can put it that way. And so it continues to be relied upon, including in the memorandum before the Dubai Court of Cassation. So it's something which is of concern to our clients, and given that the proceedings are being struck out, given that the order was never acted upon, as I say, for the avoidance of doubt, we wish that order to be there, because there is, unfortunately, some continued mischievous production of the 27th of October order and inclusion of it in the parallel Dubai court proceedings.
Yes, I understand. Now, as to, let's just think of the practicalities for a moment. It's envisaged, is it, that in a sense, the claim in the separate proceedings will be pasted in to the proceedings before me as a counterclaim. So there'll be a new pleading, which will be the defense to your client's claim, and then there will be the counterclaim that follows. And you will have liberty then to respond by way of a defense to the counterclaim. Now, could you just help me with the current state of the pleadings in TCD-003-2019, Mr. Dylan Malone? Where are we when it comes to the state of the pleadings?
Well, it is surprising that we are 2 years down the line, but it is nonetheless the case that the only pleadings, as in the index of documents before you, is that you have the claim form that issued on the 8th of December 2019, including the brief particulars of claim that were included within that. So the next step, as you know, in the TCD process, the case management conference comes early, and I want to address you on that point a little bit earlier in terms of the filing fee element. But the point is that the next step in the proceedings, surprisingly, after all the water under the bridge, is that we are now only going to be filing our particulars of claim. That the next step is for us, assuming that the counterclaim comes in and, as you say, is pasted in or treated as one of whatever mechanism that is done. Then the next step, we're saying, by the 11th of March, is that we at one and the same time issue our particulars of claim and our defence to that counterclaim. So I think that's a neat solution. And then the pleadings would follow from there as set out. So the defence and the reply to the defence counterclaim would follow by the 25th of March. Now there are then the production side of things would then kick in as set out in the paragraphs 9 and following. And that would bring us again in parallel up to the 25th of March 2021, which we believe is achievable and has been agreed. Then you would have the witness evidence. And
yes,
can I interject? This is the one thing here. If you could look at that part of the proceedings there, part of the draft order at paragraph 14. That
14. Yes, I'm looking. Yes,
it brings you up to the end of the. Production phase by the end of March.
yes.
What we would respectfully ask the court is that the filing fee, the second tranche of the filing fee, that's something like almost $22,000. It came as a bit of a surprise to myself and my client this week when because the CMC is coming up and because under Part 26, the second tranche of the filing fee becomes payable then. To be honest, I just simply hadn't anticipated it. And I'm asking the court, but given also that the defendant also, by filing its counterclaim and it being in a TCD, would presumably have to file its second tranche of its equivalent filing fee now as well. It's my respectful request in the court's discretion, if you could please allow us until the 25th of March to pay that second tranche of the filing fee. It's simply, partly, I accept our own naivety in not spotting this, that I had assumed because the CMC occurs early, that in some way the filing fee would be payable at the conclusion of when the evidence is closed. And this is not something which, unfortunately, I say this against myself, I didn't advise my client of that liability. We don't have funds on it. We don't have funds on account at the moment to cover it, and I just respectfully asked an interval of that nature to allow me to get my house in order. And that's for the benefit of the other side as well.
Now, in respect of having the pre-existing separate claim coming in as a counterclaim, is there any provision made in respect of the cost arising out of this particular procedure?
As you know, I think as you know, the ordinary consequence of an amendment would be to allow the costs of the amendment. But this is I think not the same. I think it's the costs of introducing a counterclaim. I'm not aware of any specific practice which would require the counterclaim.
No, where there's an amendment, the usual order is costs incurred arising out of the amendment made, and so there's some sort of pleading cost usually as a consequence of an amendment. But this is different, as I think you accept.
Yes, I do.
Well, what the court is imagining is that there is, in the near future, there's going to be a counterclaim, and in fact, it will be in identical terms to the claim that is made in the separate proceedings. So I don't think that there's any special, there are no particular costs arising out of this procedure of bringing in the separate claim as a counterclaim. Of course, there will, in other words, it will be treated, in terms of costs, it will be treated as if the counterclaim, as if there had not been in existence a freestanding claim, but instead a counterclaim is now coming, will be coming, in response to the claim that your clients issued a couple of years ago. So I think that's all right. Well, now looking at the, I imagine, Mr. Ghosh, I imagine you join in the application of being made by Mr. Dylan Malone that the second tranche of the filing fee should be delayed until the 25th of March.
Yes.
Well, I'm going to grant that. So that's fine. Now, is there anything else in the draft order that is not agreed or which counsel thinks ought to be explained to me? Let's come back to you, Mr. Dylan Malone.
Thank you, Justice Field. I should say, if you look at page 60, paragraph 6, the square bracket, the square bracket.
Yes, alternative, the square brackets, yes.
That all goes, by the way, in the light of your ruling.
Right, so that'll.
Yes.
I can put a line through that. What's in the square bracket?
Yes.
Okay. Very good.
The 7 is what we had sought for precisely what we've just mentioned. We had sought, and I should say that this is not, I imagine this is not a consent, even though my friend did consent to our draft order. I would, in ease of everybody, say that paragraph 7 and paragraph 8 obviously were not subject to the consent order. So again, they all fall away. The 7 did address that question, which I maintain, at least for the purposes of the record, that we do seek our costs of the TCD 2019-4, which is the application to admit the counterclaim. And then I think from there on in, Justice Field, I hope everything is in the usual form. It's certainly been agreed by the parties. You may wish to address us in relation to experts because of the nature of the case. And you'll see from both parties, from the case management information sheets, that each side agrees that there are potentially 2 experts required. One in relation to the classic construction loss arising from the competing claim and counterclaim, and the second relation to consequential loss. And I should explain that on our side, in the claim includes a substantial sum which would have to be partly counterfactual in relation to loss of rental income resulting from delay of the property, and therefore that would not be something that would be within the remit or expertise of a classic construction loss expert. And we would, we do not yet, I should say, we have not yet identified specifically or finalized specifically the identity of either expert at this point, but we can undertake probably to provide the court with the names of those experts, I would say within a month. But to explain the nature of the expertise,
I'm afraid, so sorry to interrupt you, The last 3 or 4 minutes, I'm afraid there was a technical failure at my end.
I see.
And so I've reconnected into the call. And the last thing that we were looking at, you were making some observations about paragraph 7 in the draft order, and I think linking it to my acceptance that the second tranche need only be paid by the 25th of March. Is there anything else you want to say about paragraph 7, Mr. Dillon-Malone?
No, Justice. I just wanted to point out that they weren't in, although the draft case management order has been put forward on a consent basis. Clearly, those paragraphs are not consent. Number one, that's the first point. And secondly, I'm maintaining my formal application for my costs of the counterclaim application, for the record.
Yes.
So then I had moved from there, and if I may,
yes,
to say that everything else in my respectful submission is carefully timed and we hope accords with the practice of the court, which we believe it does from other case management orders, and interlocks in a way that the parties believe is achievable in terms of the deadlines made. And specifically in relation to construction and to expert reports, the court will have noted from the case management information sheets that both parties are agreed from their respective claim and counterclaim that they may have up to 2 experts. One expert on the classic construction losses arising from the items of each of their claims. And on our side, the consequential loss aspect relates almost wholly, but perhaps in certain other minor ways as well, but almost entirely to the loss of rental income on the property resulting from the substantial delay. And that obviously involves, in part, a counterfactual assessment, which would be the remit of an economist or a suitably qualified financial expert. And as you'll appreciate, that would not be the type of expertise that would be within the typical remit of a construction loss expert. So that's why we may have up to 2 experts. But I think the other side also agrees that they may have both a construction loss expert and a consequential loss expert, and we certainly obviously have no issue with that. The point at which you rejoined the call, I was explaining to the court that from our side, we have not yet finalized the identity of the experts, but I can undertake to provide the court with those names, should you so direct. I'd suggest within 4 weeks, just to allow for the finalization of the engagement or engagements of those experts.
Yes. Well, could I just ask Mr. Ghosh for a reaction, please? Mr. Ghosh, you too would like to have 2 expert reports dealing with different areas of expertise. Is that correct?
Yes, you're right, sir. But
have you identified?
No, that's the case. Unfortunately, we haven't, and unfortunately, I have been bedridden for the last 10 days, so I couldn't do much about it. But
I'm very sorry to hear that. Are you all right now?
Yeah, I'm at home only and just lying on the bed and talking, trying to be a part of the proceedings. So it's not corona. It's, the result is negative.
Yes, I see. Well, you're doing very well in the circumstances.
Yeah, thank you.
Mr. Ghosh. All right. Now, can you tell me what areas of expertise you wish to bring before the court?
One is the
one on the construction element, no doubt. But what's the other one about?
It's again on the consequential, the delay basically, which happened, which we are saying doesn't. We are not guilty for the delay. Anyone, if somebody can make an assessment on that, the delay damages which we are claiming.
Oh, I see, on the counterclaim side.
Yeah.
I see, all right. Well, now, how long do you need to be able to identify the experts that you're engaging?
3 weeks at the most. Okay.
3 weeks. Well, Mr. Dylan Malone has asked for 4 weeks. I'll say 4 weeks.
Okay.
It should be in. It should be there should be a provision in this order that we're discussing,
yeah,
that each side is to identify the expert witnesses which have been engaged in respect of these particular areas of expertise,
yes,
within 4 weeks of today's date. Yes, thank you, Mr. Ghosh. I'll go back now to Mr. Dylan Malone. Any other matters, Mr. Dylan Malone?
I think just, I don't believe there's anything of substance, Justice Field, but I do believe that the inclusion by the defendant of the issue of whether any order as to costs should be made or not made, subject to a stay, that has been dealt with you, and therefore where that appears in the draft order, in furnishing you with the new draft order, that will come out.
Can you tell me which paragraph that is in the current order?
Yeah, I'm sorry, I'm just trying to find it here, excuse me.
Yeah.
I think it may be in the issues.
Or it's in the issues, is it, rather than the order?
Maybe in the issues. I'll double check. Yes, I think it did not find its way in any provisional way into the draft order. So I think it just referred to in the issues, but we'll double check that.
All right. Well, if it's in the issues, it doesn't matter so much. If it's in the issues and not in the order, it's not in the order.
And subject to that, Justice Field, I don't believe there's anything left to address. Obviously, we would take out the footnotes and clean it up on the basis of the directions you've made.
Yes, please. It's not a consent order. It's an order that I am making. The recitals are all in order, reviewing the file and so on, and hearing counsel and the like. And then we move straight into a conventional order made by the court. And I'll leave it to both of you to agree a final version of the order compliant with any directions and orders that I've made in the course of this case management conference. And would you please get a draft of the final order to me via the registry in short order? How many days do you need for that?
I think we can get it to you, subject to Mr. Ghosh. I think we can get it to you on Sunday morning.
Yeah, I need Patrick's help in that, because I'll request him to draft it and send it across, and I'll just review it and send it back to him because.
All right. Well, let's say by close of business on Monday, just to allow a little wriggle room. By close of business on Monday, the final agreed version of the order will be put in the hands of the registry for transmission to myself, and I will then confirm to the registry that this is the order they are to issue.
One question I have.
Yes.
The 74,000 costs which has to be paid within 10 days, is it from today?
Yes.
Or it counts from today or from the date the order comes to us?
That's a good question, but it's from today.
Thank you. Thank you.
All right. Well, thank you both very much indeed. I think that concludes all matters. Both sides have liberty to apply if anything crops up.
Very good.
Thank you very much.
Thank you.
Thank you.
Thank you.
Mather, are you there?
Yes, Judge, I'm here.
Thank you.
Thank
well,
you
I think that clearly concludes the business. There's no need for a transcript at this point.
Okay.
It's been recorded,
Yes.
and if any issue arises, we'll think about a transcript. But no need for a transcript.
Okay. Thank you, Judge.
Of
Thank you.
today's proceeding. Right.
Yeah.
Thank you, Mather, very much.
Thank you. Have a nice
indeed.
day.
I'm signing off, and the same to you. Goodbye.
Goodbye.